Testing. Service Commission's administrative docket rulemaking 81. Mr. Burkowski, I guess.
Good morning, Chair Hoover and Commissioners. John Borkowski. I'm the PC 44 Interconnection Work Group leader. At the RM81 hearing on January 9th, among other things, Chair Hoover moved to publish draft revised regulations in accordance with the changes made at that proceeding. And they were published in the Maryland Register for notice and comment, and that was on April 5th. Now, pursuant to the Commission notice for comments, two parties provided or filed comments. The Coalition for Community Solar Access provided comments on May 6th, and PEPCO and Delmarva submitted joint reply comments on May 30th, replying to the comments from the Coalition of Community Solar Access. So, notwithstanding the rest of the regulations, this is just a very narrow issue to be discussed today, in that the CCSA would like to change the wording of COMAR 20.50.09.06Q1C. I'm assuming that you have that in front of you, where the regulation paragraph states, a utility may determine the amount of reserve hosting capacity on a restricted circuit based on a circuit-specific assessment of distributed energy resource forecast or other factors including customer density, type of area served, and customer demographics of the circuit. And the CCSA requests that the Commission change the verb may to shall, and the joint comments from PEPCO and Delmarva opposed that. So I recommend that the Commission maybe ask the parties to discuss their positions.
All right, so why don't we start, I guess, with the Solar Coalition folks first, and then we'll have PEPCO respond. So, and if you want to come up to the table, if it's easier, I mean, there's plenty of room. So.
Thank you, Chair. Thank you, Chair Hoover, Commissioners. David Bugelmans, Regulatory Counsel for CCSA. I'm also joined today in the audience by Ms. Samantha Weaver, the Senior Director of Interconnection and Grid Integration Policy for CCSA. As we indicated in our written comments, CCSA has proposed a discrete edit to COMAR 2050-09-Q1C to further align that regulation with what we believe is the clear intent of the Commission. And as the work group later indicated, CCSA simply proposes changing the word may to shall. The Commission originally adopted this specific regulation in 2019 as part of RM68, following the recommendations of the PC 44 Interconnection Work Group Phase 2 final report. The work group proposed allowing each utility to reserve hosting capacity to ensure the grid can accommodate smaller generators like rooftop solar, especially in areas with significant mid-sized generator and community solar growth. And the recommendation, we believe, was clear. Utilities should determine reserve hosting capacity on a circuit-by-circuit basis, and if DER forecasting is not available, do so considering customer density, area type, and demographics. And this intent, again, we believe was included in the original version of Q1C. Despite this clear directive from nearly 5 years ago, the PHI utilities continue to impose system-wide administrative limits on reserve hosting capacity based solely on circuit voltage without considering specific circuit characteristics. For example, PHI restricts the aggregate capacity of solar facilities to 1 megawatt on 4 kV circuits and 3 megawatts on 12 kV circuits, irrespective of the circuit's specific capabilities or locational circumstances. This blanket approach does not consider actual grid conditions and limits community solar development in areas where higher capacities could be accommodated. I believe you'll hear in a minute from Mr. Wallace on behalf of Turning Point Energy what the practical implications of these limits are on developers. In CCSA's experience, the use of these administratively set hosting capacity limits is highly unconventional and nearly unprecedented among states with similar goals. Most states rely on detailed circuit-by-circuit analysis and assessments, and neither BG nor Potomac Edison do what PHI does here in Maryland. In its comments responding to CCSA filed on May 30th, PHI incorrectly claims that a circuit-specific analysis for reserve hosting capacity has always been optional, relying mostly on the Phase 2 workgroup report from 5 years ago, where it states on page 31 that DER forecasting capabilities will, quote, take some time and effort to be developed. And then from this sentence, PHI concludes that it was, quote, explicitly recognized that the implementation the circuit-specific HCA was not something that was immediately feasible, but that would require time to implement. Respectfully, it's our position that PHI ignores the broader context contained in that report, as well as the existing wording of Q1C. We believe the report is clear that DER forecasting will be useful in determining reserve hosting capacity and should be used when available. However, the report also states that a circuit-specific analysis is still required even before DER forecasting systems are in place. Specifically, if you look later on the same page, 31 of the Phase 2 report, it states, quote, reserve hosting capacities on restricted circuits should be circuit-based instead of a single limit for all circuits set by utility policy. Until DER forecasting is developed, utilities may elect to establish reserve hosting capacity policies for restricted circuits based on specific DER and circuit information available to them and the type of area served, since the amount of potential DER penetration is likely influenced by whether the area is urban, suburban, or rural. And reflecting this intent, the original language of Q1C provides the option to use DER forecasting or other delineated factors when determining reserve hosting capacity on a circuit. So in other words, the use of the word or provides that optionality. PHI is simply wrong that the implementation of DER forecasting is a prerequisite to conducting a circuit-specific analysis of factors such as customer demographics. Again, if DER forecasting is unavailable, Q1C allows the use of the other factors that are listed in the regulation. PHI also ignores in its comments that the reserve hosting capacity issue was further examined during the RM81 rulemaking and in subsequent workgroup phases. For instance, the Phase 5 workgroup report submitted in RM81 in 2023 notes on page 51 that, quote, it is clear from the wording of Q1C and 1D that the amount of reserve hosting capacity should not be administratively set, but should vary based on the factors described in Q1C and 1D. These regulations do not need to be revised, but the utilities need to comply with them by not administratively setting reserve hosting capacity to a value, such as 3 megawatts. And then further, on page 60 of the Phase 5 report, it states that at a minimum, the Commission should expect to see differentiation of the amount of reserve hosting capacity available between urban, suburban, and rural feeders, and not just differentiation by feeder voltage level. And PHI is doing exactly what the Phase 5 report says that it should not do. CCSA did try to address this issue in the initial rulemaking in this proceeding, recommending that the Commission add the language based on a circuit-specific assessment to Q1C. The Commission accepted this edit, again, we believe expressing its intent to require electric companies to conduct a circuit-specific analysis when determining reserve hosting capacity, but one additional issue was missed. The regulation still says may, and respectfully, it's our position it should be changed to shall. And the issue we're having today with PHI, I think, is an example of the importance of that clarity in that regulation. PHI should have been aware of this policy since 2019 with the Phase 2 report. We're now almost 5 years down the road. We have another workgroup report from 2023 confirming this policy, and even an effort in the last rulemaking in this case to address this issue. PHI now states that it doesn't have the ability to comply with Q1C and won't be able to do so until 2028, a full 9 years after the Phase 2 report was issued. However, these claims seem to be based on PHI's timeline for implementing DER forecasting capabilities, which again, we don't believe are required to to comply with Q1C. Again, if DER forecasting is not available, they can use the other factors listed when setting reserve hosting capacity. So really there's this middle ground between what PHI is doing now and the ultimate goal that we believe they should and must do now. To the extent PHI is unable to comply with Q1C, it should be required to file some form of remediation plan with the Commission to bring the utilities into compliance with this regulation. And this plan should, again, include interim solutions, again, this middle ground that's available before 2028 to address this issue of compliance with the regulation. One final point I'll make is we still believe that this change could be made without republication in the Maryland Register. Again, if you trace back the history with the Phase 2 report, the Phase 5 report, and the most recent rulemaking, we believe the Commission's intent was clear here, and the mere fact that PHI is not in compliance with this regulation does not mean that the regulation needs to be republished. Respectfully, we believe this policy has been well known for the past 5 years. With that, I know that was a lot. We really appreciate your attention this morning and happy to answer any questions.
So, any questions for Commissioner Barvey?
Sure. Thank you, Mr. Chairman. Two things. So on that publication argument that you've rebutted what PHI is saying, let me just ask this question. During the course of this entire process over these years, has the may versus shall issue been addressed specifically?
Not to my knowledge, Your Honor. I think it was an oversight. I think maybe it has to do with the way the regulation's written, and it just didn't come to people's attention that may really should be shall in this instance. I think if you trace things back through the reports, I think it's clear it was assumed that this was something the utilities should have been doing, to the point that I think it was clear it was mandatory. But to my knowledge, this has never been brought to the Commission's attention explicitly.
But it's always been in the document. It's always been in the written words of the proposed regulation.
Correct.
Okay.
Yep.
Second and final question is this, and I'm still feel like I'm relatively new at this job, so let me just ask this question. If we were to allow the may language to stay, what would be the process then for getting a what would be the process for getting an assessment of the capacity? Would your clients have to request it, and then would we have to approve it as a commission? What would be, the reason I'm asking this is because if the language is may, and if it's truly this difficult for PHI to do this kind of analysis, there's a possibility that they'll never do anything, and so there must be some process for making them do it. Does that mean you're going to have to come back to us?
The best I could think of, Your Honor, would be some form of complaint. But again, I think what we've seen from PHI's comments is their position is that may really means may here. And so it would be an issue in front of the commission, and then eventually I think it could make the way, to the commissioners for a decision. But we filed these comments for a reason, is because we think from a legal standpoint, this regulation really should say shall if the commission intends for this to be mandatory. And without that, yes, there could be ways to bring this issue up to the commission, but we didn't want to go down that road without addressing this drafting issue first.
Okay, thank you, Mr. Chairman.
Anybody else? Commissioner Richard?
Just, I think you said this, I believe, but you said for Maryland, this is only an issue that you're finding with PHI companies and not with PE or BGE. Is that correct?
That's correct.
Okay, and then that you said you found this, I think in your filing, highly unconventional and nearly unprecedented among states with similar clean energy aspirations. So this is something that I guess the solar industry hasn't really faced in other states, or I'm just trying to understand how we got here with just one of our companies not able to.
Yeah, that's my understanding. I could ask Ms. Weaver, who I think has experience all over the country. She could talk a bit about what other states have done and her experiences.
Sure.
Thank you. Here, there we go. Yeah, so
Actually, can you identify yourself for the court reporter?
Yes, thank you. Good morning. I'm Samantha Weaver That's WEAV as in Victor ER. And I'm with the Coalition for Community Solar Access. I'm the Senior Director of Interconnection and Grid Integration Policy there. It's nice to see all of you again. To Mr. Buchelman's point, it is our assessment at CCSA, where we work all across the country, that this practice is unconventional and unprecedented, and I can talk a little bit more about what I mean by that. And typically, well, let me back up and say that this challenge stems from a policy choice to reserve space on the grid or capacity for smaller scale solar systems. That practice alone is uncommon. However, it is one way to make sure that rooftop solar and community solar don't have to compete for the same amount of space on the grid. So sort of setting that issue aside, I did want to just start there because that's really what this question is about, is what's the proper way to reserve capacity for rooftop solar. Typically in other states that have grappled with this, they are required to study each individual circuit as part of the interconnection process. So what that could look like is it could take place during the study process, the system impact study process, and any limits on any interconnection limits are based on some justification that's technical in nature. So it could be voltage related, concerns about thermal overload, things that are described on a circuit specific basis and in the context of an interconnection study. So that's kind of our ask here, is that that there be more granular information and that any limits on which projects can interconnect where be justified based according to conditions at a given location. The approach here in Maryland to have this sort of blunt instrument approach to the entire utility system is the piece that is highly unconventional. And I think, initially when we were discussing this, I was aware of only one other state where this practice existed. That state has since done away with that practice, although there is now one other state that's considering a similar approach. So again, across the 23 states or so where CCSA is active, this is the only place we see this occur, where there's a blanket rule that, for example, you can't interconnect more than 3 megawatts on a 12 kilovolt line. Typically what you would do instead is require that a given line be studied, and in the case of the Maryland regulations, one thing that the utilities could do today is consider whether, is that line located in a rural area that has, very few residential customers, looking at, as the regulations say, customer demographics, customer density, et cetera.
Okay, thank you. And Mr. Chair, I was going to ask if they wanted to respond to any of the company, but I guess we should hear from the company first.
Yeah, actually, so
Okay.
we'll sort of get to them.
Okay, and then there was a discussion about a workaround, a remediation plan, but again, maybe that's
Yeah,
something that's
sure.
later in
Yeah,
the
sure.
conversation.
Yeah.
Okay, yeah. All right, thank you, Mr. Chair.
So, anybody else, any questions for, okay. So I take it you're in support of the change, correct?
Yes, Mr. Chair.
Okay, so
Turning
go
Point.
ahead. Go ahead. Yeah.
Yeah, Eric Wallace with the law firm Green Herlocker on behalf of Turning Point Energy. And Turning Point is a member of CCSA and a very active developer in this community solar market here in Maryland. They've been involved in developing projects here since the inception of the Community Solar Pilot Program back in 2016, including working on hundreds of sites within the PHI footprint and trying to identify sites that are viable from a site control standpoint, interconnection standpoint, permitting standpoint, and Turning Point has really identified this issue, this system-wide voltage-based circuit capacity issue, as the largest barrier to developing community solar projects in Maryland. So we just want to highlight that this is a critical issue. We appreciate CCSA's comments kind of walking through the details of the regulations and the history and how we got here. But from Turning Point's perspective, I wanted to highlight kind of what this means for a developer that's trying to build projects in Maryland today, and where we want to see this go to make development work better and to make community solar able to come online throughout the PHI footprint. This is, in Turning Point's view, this is even more important, even a bigger challenge than siting right now. This is a threshold barrier, and in Turning Point's internal analysis, they believe that they would be able to have roughly double the amount of community solar online in the PHI footprint had this circuit capacity limit issue never been, right, since the beginning of 2016. And what we want to be clear about here is that we're asking that the commission direct the company to do the studies that are contemplated and required under the COMAR and move away from this threshold circuit capacity limit. I mean, for example, on a 34.5 kV line, the aggregate DER capacity limit is 10 megawatts, right? So when a developer submits an interconnection application for a site that is on a circuit where there are other projects, right, the first thing that is happening there as part of that study process is the company is looking to see, is there 10 megawatts on that line? If there is, that project gets kicked to an express feeder requirement. That contrasts with other utilities all over the country, including BG and Potomac Edison, that when they get the interconnection application, they're going through the study phases. They're looking to see, can we safely interconnect this project to this circuit based on what's actually happening on this circuit, and looking at what constraints may be there, the actual characteristics of that circuit. And an important takeaway here is I asked the engineers, if we got rid of this 10 megawatt cap, say for a 34.5 kV line, what level of capacity might we expect would be able to be interconnected? And the rule of thumb they gave me is it's usually around 1 megawatt per kV, right? So a 34.5 would be somewhere in the 20 to 30 to 40 megawatts of aggregate capacity available. This administrative cap is 10 megawatts, but they shared with me examples of projects of circuits all over the country that are having 20 plus megawatts on them. And so really what this means is we could have 2 to 3 times as much DG capacity on these existing circuits without triggering a new express feeder to be built out for community solar projects that are coming along. And that's what we want to move to. We want to get away from this administratively set cap by the PHI companies and look at, okay, if we're going to reserve capacity for rooftop solar projects, we need to do an assessment to see what's the appropriate amount for that specific circuit. But right now we're very far from that. We're starting with this arbitrary cap that is eliminating hundreds of sites that Turning Point has investigated over the years to try to develop projects. Right now, under development, they have about a dozen sites that are facing several $1 million interconnection upgrade costs on existing circuits because they need to build out an express feeder under these rules. And so those projects likely will not be able to move forward because they can't burden that or shoulder that kind of an interconnection cost burden. So, at the end of the day, this issue is about moving to, actually studying projects, looking to see and trying to maximize the amount of solar that can be safely interconnected on these circuits based on an individualized study process, rather than putting in this arbitrary barrier that kicks them out of the study process once an aggregate of 10 megawatts is hit for each 34.5 kV, and the threshold drops down from there for the smaller lines. So, the point of Turning Point's comments here is we really want to support CCSA's request here, and look to find a path to resolving this issue sooner rather than later, right? We can't wait until 2028 to be able to start looking at additional sites. These projects take several years to develop and to bring to commercial operation, right? So if we don't have a solution to this issue until 2028, we're looking at being into the 2030s before, sites that could be developed today, absent this rule, are sitting on the sidelines waiting for PHI to build out the software tools that it intends to use to be able to do the site-specific assessment in the future. Thank you.
Okay, any questions for Mr. Wallace? So before I turn to the company, let me just check a couple other boxes. So OPC, do you have any view on this? Positive, negative?
Good morning, Your Honor. Jacob Auslander on behalf of the Maryland Office of People's Counsel. We don't have a specific position on this request. I think one concern that Mr. Bugelman's addressed was whether the change that they're requesting would hold up the final effect of the regulations. We would not want to see that happen. However, we do support CCSA's overall point that hosting capacity analysis needs to be improved, and to the extent that PHI is an outlier within the state regarding the calculation of these hosting capacity reserves, then we do think that that's a problem, and the commission should take action.
Okay, any questions? Alrighty. Mr. Dean, staff have any thoughts on this?
In general, the use of may, should, or shall isn't normally an error in the regulations and in the proposed regulations. A lot of thought goes into that, and as such, if there's a need for republication due to that, I would say that there would be a need for republication, because those are very big differences in the regulation.
Okay, any questions for staff? All right, so PHI, the floor is yours.
Thank you very much, Mr. Chairman, and good morning, Chairman and Commissioners. Matthew Seegers, appearing for Pepco and Delmarva Power. I have with me some subject matter experts who can answer any technical questions that I'm not able to respond to. The PHI utilities, as we discussed in our comments, we actually agree with CCSA that the intent of COMAR Section 2050-09-06Q1C is for utilities to eventually reserve hosting capacity on restricted circuits in a manner that accounts for factors such as customer density, type of area served, customer demographics of specific circuits. In fact, it was CCSA's own revision during the first rulemaking to specify the circuit-by-circuit analysis. We did not oppose that revision because we agree that is the eventual intent of the COMAR regulation. We also specified in our comments the various steps that we are taking in order to achieve that goal. However, as the Phase 2 report, which CCSA itself cites to it in its comment, as that explicitly states, more robust DER forecasting methodologies must be developed in order to provide the granularity and the accuracy needed to implement circuit-specific hosting capacity analyses. That, I don't believe, is a matter of interpretation. The Phase 2 report explicitly states that. It also made it clear that that is not something that was immediately going to be feasible, but that would also require significant time and effort to implement. If CCSA's proposal was adopted now, it would result in PHI, essentially our capability would either result in overly conservative assumptions that unnecessarily reduce a circuit hosting capacity and suppresses the interconnection of additional DERs to that feeder, or, on the other hand, assumptions that are not restrictive enough, which could lead to too much DER penetration and impact safety through increases in arc flash energy, as well as impact reliability through an increase in fault current, causing miscoordination and the potential misoperation of automatic circuit reclosers. And on the issue of republication, Your Honor, just looking at the Attorney General opinion that is quoted in the CCSA comments, I don't believe there's any question that if this change was adopted, it would require republication. We talked about how this would be a major imposition upon the PHI utilities specifically. Also, at the very end of paragraph 2 of that, it says, or if the agency is uncertain about the significance of the change, the agency must republish the changed part. The very fact that we're having this discussion is evidence that there is at the very least a question as to the significance of this change, and that would require republication, which is not what we at the PHI Utilities want. We want to get these rules implemented and then move on to the next phase. With that, I am available, and my subject matter experts are available if there are any questions.
So, questions for PHI. Commissioner Suchman.
Good morning, Mr. Seegers.
Good morning.
Okay, so as I understand it, you don't have a problem with the substance of what is being asked in terms of the language change. It's a matter of timing for the company. Is that so? You don't oppose the more granular information.
Absolutely not, Your Honor.
Okay, so walk me through what's in place now, because as Mr. Bugelmans has stated, this is not a new issue. This is something that the utility has been aware of. That you know, in order to deploy as much DERs as the system can hold, we need to have a robust system analysis. We can't rely on arbitrary administrative caps. So walk me through what's in place now for the PHI companies and what you would need to implement in order to satisfy this regulation if we had changed the may to shall.
Sure, I can definitely try to. We spoke in our comments about the limits that we currently have in place right now, which are, they are by voltage, and they are based in part on a 15% limit that is specified in the Comar interconnection rules.
No, I read your comments.
Okay.
So what I'm trying to understand, I mean, I got from the comments that you don't have the software capability at this point to be able to do the kind of analysis that a shall would require.
Not yet, Your Honor, but we are moving towards there.
Okay, so I'd like you to walk me through what's in place now and what would need to be changed in order to get you there.
Okay. My understanding, and I can bring up my subject matter
Maybe
experts if I
you want to
can-
bring the subject matter.
Okay, let me see if
Yeah.
I can bring them up.
Okay.
Morning. I'm Abdul Rahman Kabu. I'm the manager for DER Engineering and Advanced Analytics.
So you have to speak up a little bit.
Okay.
Thank you. You know, I'm old and
Yes. I'm Abdul Rahman Kabu. I'm the manager for
Actually, and can you spell your name for the court reporter just so we get it accurately? So,
It's A as in Alpha, B as in Bravo, V as in Delta, U as in Umbrella, L as in Larry, A as in R as in Romeo, A as in Alpha, H as in Hotel, M as in Man, A as in Alpha, and N as in Nancy. That's my first name. My last name is Kagbo. K as in Kansas, A as in Alpha, R as in Romeo, G as in Girl, B as in Bravo, and O as in Oscar.
okay, thank you very much.
so
go ahead.
Mr. Carbo. Yes, good.
So what we have right now, what we've been working on, and we do agree with CCSA position. What we've been doing with in terms of reserve hosting capacity and the limit that we have on the feeders right now. I'm sensing a little bit of confusion. Let me just clear that out. In terms of reserve hosting capacity, it's actually done for reserve hosting capacity for rooftop solar. It's actually been done on circuit analysis, like we run our DW analysis overnight and see what the status of the feeder right now based on connected DW on the feeder, and that's how we publish our hosting capacity.
Okay, so you actually look at the capacity of the feeder.
And that's how we publish. That's how we publish our hosting capacity maps.
Okay.
The limit that we have right now is for large DER, and that's where community solar over 250 kW is affected. So the limit that we have on feeder right now, the 3 megawatt and 10 megawatt, is for large DERs. Anything over 250 kW that needs to be connected on that feeder, we have an aggregated limit for large DERs.
Right, but do you have the capability to do an analysis on the specific feeder to determine what the capacity is for that feeder, as opposed to sort of these arbitrary limits?
We currently, we're moving in that direction. We don't have those readily available. But what we've done is since 2019, we've identified business needs, and that includes us trying to move from our existing software that we used to do circuit analysis, which is DW, and we identify business needs, and then we source vendors and see their capabilities. And now we're trying to move to SIME, which is a new software that we actually move us to that direction, for us to do a more granular circuit analysis, for us to come up with these detailed hosting capacities.
Okay, so it sounds like it's a work in progress.
It's a work in progress.
Right, and you have some capability now.
We have some.
Which you are using, but you may not get to 100%. Okay.
We may not, and that being said, is because for the two alternatives that CCSA have, that the regulation have right now, one is to do a DER forecast, which is identifying a feeder and projecting how much DER, like rooftop DER, that will be coming on that feeder over a period of time, which right now it's a little bit of challenge, and we might have to have different, and we're also working on that. We're working on having a detailed DER forecast. In that case, we try to factor in understanding what the regulation in this area, what's the appetite for individual customers to actually move in solar direction, and that's all factors those are arbitrary factors, these are assumptions. And Matt actually mentioned that if we factor those in right now and make those as assumptions to make our DER forecast, it will lead us in two answers. Either we make conservative assumptions and limit the DER forecast, the DER hosting capacity, or we actually make some wide open assumptions and allow more DER to tie into these feeders, thereby compromising the safety and reliability of those feeders.
Okay, but is it possible, for example, if Mr. Wallace has a client that wants to build community solar, comes to Pepco, is it possible that particular project, you might have the capability to do a more granular analysis because you've already looked at a particular feeder and you sort of have that information, whereas perhaps another feeder you're not quite ready to do that kind of analysis. So in other words, are there, as opposed to sort of either 0 to 100, are you sort of in the middle where you might be able to do it for some and not for others?
Yes, so we also have an option for detailed engineering studies before we recommend a express feeder for a customer, we sometimes first recommend a detailed engineering study that we do on those feeders to see if we can accommodate additional solar in that feeder that will not actually trigger a express feeder construction. But that has to be done separately, and we can't do that for all feeders. That has to be done maybe on a case-by-case basis for right now. We can't do that for all the feeders because we don't have that capabilities right now.
But you can do it for some.
On a customer requested engineering study, and the limit for that is it has to coordinate with our reliability team and our system protection team to see if the existing asset that we have on that feeder right now can accommodate or can coordinate well with the new solar that applying to connect on the feeder.
Okay, so Mr. Cargbo, I'm wondering if we were to have, for example, a requirement that you do this more granular analysis when an interconnection request is coming in, but you have the ability to come back to us to say, well, on this particular project, we don't have the necessary software, so we're really going to have to use an administrative cap. Would that give you some comfort that you will be able to do the work you need to do where you have that capability, and as you're moving forward, you'd have to come back to us less and less for some kind of waiver. But so that the assumption would be that you would do the kind of granular analysis that all of the other utilities are doing, but that in situations where PEPCO doesn't have the necessary tools at that moment, you would come to us and talk to us about why it can't be done. Would that give you some wiggle room, some comfort to be able to do your job without us making you spend a lot of money right now putting in the kind of software if we were to put, for example, a shall with no conditions?
No, that would still be a challenge, because the amount of resources that we need to do an individual granular study on each feeder, considering the amount of solar that we have, solar applications that we have coming in on a day-to-day basis, it will be us coming here almost every day to update that we can maybe have those capabilities to accommodate any new application coming in. So,
but you couldn't know when the application comes in, this is actually something that we don't have the capability to do right now. Whereas some projects you can.
Your Honor, can you rephrase the question again?
Well, I'm trying the company is moving in a direction.
Yeah.
So you actually are moving. So it's not like you don't have any capability right now. You are moving in that direction. You're just not where I'm assuming BGE is in terms of doing the more granular analysis. So I'm trying to determine whether there's an opportunity here to at least establish that this is where the Commission wants PHI companies to be. We want you to do that granular analysis, but that we recognize that you may not be there, and so we're kind of giving you an opportunity to come to us for a waiver in situations where you don't yet have the capability. And Mr. Bugelmans had sort of offered several different types of analysis, that it doesn't have to be just one analysis. But assuming you can't do any of those, and you want to rely on that arbitrary cap, at least to come to us and explain the situation so that we can sort of work with the parties to figure out how to move forward. Since I think everybody wants to get to the same place.
Exactly.
The question is, how do we get there?
That's so.
And this may actually be a question for Mr. Seegers as opposed to, but I just wanted to get from an engineering perspective. It sounds like there are situations where you can do the analysis, the more granular analysis, and situations where you can't.
So let me be clear on that. Our limit on voltage class is not just arbitrary. It's a system protection and reliability limit. So it's not saying we're limiting this 3 megawatt based on, because it's
Yeah, but it's not based on the kind of granular analysis. It is arbitrary in the sense that you've picked a number that is based on engineering principles, but it is a number. It's a cap,
Yeah.
and it's not looking at the feeder itself. It's just sort of, it's making an assumption that this is how we're going to move forward, and we're trying to get away from that. And Mr. Seegers has said that that PEPCO is moving away from that. You're just not ready to be there 100%. And so I'm trying to determine whether you're, if you're there, if you're 50% of the way there, then that's 50% that will benefit from some kind of analysis while you move to the final 100%.
So I'll allow my Brett to speak on this from a system protection standpoint, and only because for us to move away from this limit, safety and reliability is a key thing in this, and he might be able to speak on this a little bit more.
Good morning. My name is Brett Winke, Wienke. I'm a senior engineer in the System Protection and Control Group for Delmarva. So I guess one of the concerns that we have is the reliability, excuse me, mostly to do with the coordination of relays and reclosers that are on the feeder. In order to do a detailed study on that information, we need a short circuit model, which is what this SIME software we're talking about is. And so in order to do a proper analysis on the reliability on setting the relays to make sure more customers aren't interrupted than necessary, we need this short circuit model to do that detail.
Right, and you can come back to us. I mean, what I'm trying to, I don't know that we necessarily have to have all the answers today about the kinds of studies that need to be done and the reliability issues. I think if we can sort of establish perhaps a process that would have the default be a system analysis, but that if you need the kinds of relay studies that you require and that you can't really move along without that, you can come to us and ask for a waiver. And we could win, and assuming that you've made your case, we can grant the waiver, and that would allow you to to stay with that cap until you have the necessary tools in place. Mr. Siegel, would that work for PEPCO? And I guess Mr. Bugelman's is would that work? I mean, I guess so. I'm actually sort of throwing out the possibility that we change may to shall, but we include language that sort of could read a utility shall except when waiver is granted for good cause shown. So you'd actually have to come to us for a waiver, and you'd have to tell us what's going on and explain to us why those, because we should be. I don't know why PEPCO is where it is in terms of the analyses, because this is not a new issue, but so I think that I think the default should be that these studies should be done, but then at least I sort of recognize that there are situations where for whatever reason you can't do it. You could come to us and say in this particular request, we are asking for a waiver.
Your Honor, if I can just understand what, by waiver, are you talking about a waiver from the regulation for all interconnections?
No, waiver for this particular requirement, so that the waiver would be that you can go back to your administrative cap and say, well, we can't really do the study on this for this particular reason, so we need to cap it at 3 megawatts, whatever that cap is.
I mean, we can always ask for waiver of any of the Commission's regulations, and then the Commission can grant that.
But this would be built into the regulation, so that there would be an understanding that for good cause shown, we would grant you the waiver.
Well, if we're going to build that into the regulation, I think that would definitely require republication, Your Honor. Just to,
yeah, we're not dealing with that issue right now.
Okay.
Let's one issue at a time.
Matt.
Okay.
Can I add something, Matt?
Well, actually, as long as you identify who you are for the record, you can
Sure.
go ahead and add whatever you want.
Hello, my name is Rose Jojic, Jojic. I'm with PEPCO. One thing that I think is coming up here, Commissioner Suchman, is that we're talking about potentially big impacts that have policy decisions, and I think the right forum for these discussions are within the working group. So for what it's worth, within the PC44 interconnection working group, TIR discussions was on the docket for phase 6. We've had to repurpose some of the discussions to prioritize legislative priorities and some federal orders, but that has been tabled to be discussed in phase 7, and John can correct us on the timing. So one thought here is, rather than adding the waiver language, we could use the interconnection working group as a forum to have these really detailed discussions about the specific policies that could be in place to support the utility in complying in this analysis.
Yeah, I'm not
Well,
sure this
actually,
is a policy. Okay.
Well, let me just ask along that line, Mr. Burkowski, does this suggestion make sense? Or are we too far down this road?
Well, we do have scheduled in the work group, as Rose indicates, to address this issue again. We're going to look at all of the utility technical interconnection requirements that aren't necessarily spelled out in regulations, and this one happens to be spelled out in regulations. But we're going to look at all the technical interconnection requirements. But we won't get to that this year with a proposed rulemaking because we're focused on the Drive Act and trying to implement that at this point. But I would, if the chair would allow, I would like to just give my perspective.
Well, actually, let me
Okay.
make sure. Are you?
Yeah, no, I just, it seems to me that this is less of a policy matter than it is a software matter. I mean, it just sounds like Pepco doesn't have the necessary tools in place to do this 100% of the time. So it also sounds like this is not something that Pepco objects to. So in that sense, I'm not sure that this really is. It's a timing issue, I think, more than anything else. Unless I'm misunderstanding what Mr. Seegers is suggesting, you don't have a problem with doing this analysis. You're just not able to do it right now. Is that? And so in that sense, that's it. So it's not really a policy matter.
Your Honor, can I say something?
Yes.
We have, in terms of why we're asking, I mean, why we're pushing on this timing, we have approximately 15,000 feeders across the PHI landscape. And doing a circuit-by-circuit analysis, which each one, with a manual engineering study, I'm pretty sure will be maybe 365 days a year to just ask for waiver.
Well, but somehow BGE is doing it. So somehow, and I'm assuming they have a lot of feeders also. So somehow they're able to do it. I'm assuming they've found a way, they've figured out a way to do this, and I'm assuming that Pepco can get there too.
If I can, if I could just address that very quickly, Your Honor. One thing to keep in mind is that while there may be other utilities that may be able to get there quicker than the PHI utilities, it's important to keep in mind that the PHI utilities we're a little bit unique. We're the only entity that are operating two utilities within the state of Maryland, both of which have different distribution systems, and they are going to require that the software has to be very carefully tailored in order to accommodate those differences in the distribution systems. Moreover, we operate in multiple jurisdictions, and this is going to be an implementation not just in Maryland, but across our jurisdictions. We have to make sure that it's going to work in all of our jurisdictions. So I'm not really sure, while there may be other utilities that have that capability, they are not as uniquely situated as we are. That may be one explanation for why it may take us a little longer to get to that point.
Well, and that's why if we put some waiver language in, and so we're dealing with a real world situation. Mr. Wallace as a client comes in, you're seeking a waiver, you come back to us and you talk to us about the specifics of that situation. All this is doing is it's just creating a process, and with a suggestion that the default is the granular analysis. But if it can't be done, you can come to us and tell us why you can't do it. I mean, I personally would like to have sort of a better sense of what's going on with the company and why it's taking so long. And so that may actually be part of the discussion to the extent you come back to us with a request for a waiver. But that's why I'm sort of offering this as perhaps a way to move forward, so that it kind of recognizes where the commission has been wanting to go, which is to get a little bit more granular in terms of the capacity on these feeder lines, but at the same time recognizing that you may not be there yet. And so this allows for a waiver.
And actually, if I could follow up on your last point, I mean, you have two widely different service territories between Delmarva and Pepco. So is this more a Delmarva issue or a Pepco issue, or is it in fact equally affecting both?
I can defer to my subject matter expert, but I think it's equally affecting both. I mean, as I said before, we're going to be implementing this across both utilities. So a software that may work for Pepco may not work for Delmarva Power and vice versa. So that's, I mean, if that answers your question, Your Honor.
And in regards to the multi-jurisdictional things, I mean, PE operates in a number of different jurisdictions, but apparently this is not a problem for them. Now, I know you can't talk for PE,
Right,
but
right. I
just
can't speak to-
trying to recognize the fact that I understand you have to deal with Delaware, you have to deal with DC and us, but they have to deal with West Virginia and Pennsylvania. So.
Correct, but I don't know if First Energy, if they have implemented this across all of their jurisdictions. We are going to be implementing this across all of our jurisdictions because from an implementation standpoint, that makes sense. It also benefits all of our jurisdictions. So unfortunately, I can't speak to whether or not those are comparable.
Yeah. Commissioner Barbe.
My question's been asked.
Okay. Commissioner Richard?
I am interested to hear from the industry. You've been trying to be heard, so why don't, I'm interested in your comment on what you've heard.
I appreciate that. Thank you, Commissioners. Samantha Weaver with CCSA. I did want to thank you for acknowledging me. I did want to address, I think it was Commissioner Suchman's initial question about sort of how did we get here today. So I wanted to offer, my perspective on that. Before I do that, I wanted to also mention that I think there are two discrete issues that we're sort of conflating here a little bit in this discussion. There's first the issue of how do utilities calculate hosting capacity? How do they do a hosting capacity analysis? The second issue is how much of that hosting capacity should be reserved or set aside for smaller scale generators. PHI has the ability to calculate hosting capacity. They're doing it right now. You can go online and look at their hosting capacity maps. So again, this issue is what's the appropriate methodology to determine how much of that available pie to set aside for rooftop versus larger scale PV generators. It's our opinion that PHI could do two things today that don't require new software. One of those things is, as the regulations say, take a look at customer demographics on a given circuit. You don't need power flow analysis to assess customer demographics. The other thing they could do today, which is a little bit more technical, but bear with me for just a moment here. So PHI, as we've heard, is setting its circuit capacity limit, so that 3 megawatt rule, based on two sort of input assumptions about peak and minimum load on its feeders. So they use kind of a rule of thumb approach here. Setting aside for a minute that itself is inconsistent with the regulation requirement to determine reserve hosting capacity based on customer density, type of area served, and customer demographics. So again, setting that aside, that method itself is also very conservative. It doesn't rely on actual data. Again, it's a rule of thumb-based approach to their entire system. PHI has access to data, like annual peak and minimum load at a given location. So where they have substation and feeder load measurements, these could be easily utilized in lieu of their assumed values without requiring circuit modeling. So the contention here that a DER forecast is necessary, that I've heard a lot of software names thrown out here, SIME, et cetera. That's great. I think our view on that is that this conversation feels like going from walking to driving a Rolls Royce. We would love to get to a Rolls Royce by 2028, but there are things we can do today that would allow more resources to interconnect and would require PHI, as many other utilities do, to study individual project requests based on conditions at a given location. And again, overall, lead to more DER penetration. The last thing I want to address is, a commissioner's question about what is like walking you through the process of what this looks like for a project developer. I'm sure that Mr. Wallace can address this as well. But when a developer, finds a site and attempts to interconnect, rather than being studied, if they're at a site that has, is bumping up against, say, the 3 megawatt limit on a 12 kilovolt line, they don't get studied. They're told that their only recourse if they want to build the project is to build a dedicated feeder, an express feeder, that is frankly often very expensive. We're talking in the millions of dollars. Community solar projects have thin cost margins. They can't always support that. And that's not a good way to build out the grid to integrate more DERs. It's frankly underutilizing the system. So again, support the idea here that, getting to a really robust set of modeling software is great, but there are things we can do in the interim that are more fair.
Great. Well, thank you for that. And Mr. Chair, I'm not sure where we are in the discussion, but I'll just say that I'm very much in support of CCSA's request. I think that this is something we need to do if we're going to meet our goals in Maryland. I think our BC 44 has been in meeting for quite some time now, so I'm a little surprised that we have one outlier utility that's not able to meet this. So I think along the lines of Commissioner Suchman, if a utility can't meet some requirement, they can always come to us and explain why, and give the other side an opportunity to respond to that. But anyway, I just thought I would state now that I would be supportive if that's the direction you'd like to go. Thank you.
Mr. Barbe.
Yeah, I have a question for Ms. Weaver. Sorry, I couldn't have timed that worse, could I have? So let me just for my clarity, I think I heard you say that even without software, this is an analysis that can be done currently. Might be very laborious, but without the software, the analysis can be done. Is that basically what you're saying?
I'm saying that, yes, that is what I'm saying. That there is an analysis that can be done. It could be done at the substation level. That's fairly common. It could be done at the feeder level that looks at actual data that exists today. It's not something where we'd be asking, you all to run simulations for every single feeder, but it would be based on site-specific conditions of each feeder. In other words, what's the actual load for each feeder or substation?
Thank you.
Okay, so I take it you have a response to what she's just said, correct?
Yes, I do. For certain studies, I think that's accurate. But when we're talking about the reliability impacts and the safety impacts, that is a circuit-specific analysis that has to be done to determine what the impact of that DER will have to those aspects.
If I could just respond briefly, I agree
Actually,
with. I'm sorry.
Well, the only thing I would say is I don't necessarily going to get into an engineering debate. So I'll allow you to respond, but if you could make it very concise and brief, because I'm concerned that we're headed down a rabbit hole on this. So.
Certainly. Commissioner, I've maybe in one or two sentences here.
Sure.
I understand and agree that there are safety and reliability concerns when you start to get to high levels of DER penetration. Those concerns about safety and reliability have an existing process for addressing them. It's the system impact study. It's the interconnection process. What we're asking here is for the utility to study individual project requests via that interconnection process, rather than setting a blanket limit for its entire system.
Okay. So, Mr. Wallace.
Yeah, just very briefly, Chairman, Commissioners, and we've had a robust discussion about this issue, so I won't, go over all the points that have been discussed. But I think the key takeaway here is there is this forecasting issue about how do we forecast how much rooftop solar there may be on a circuit in the future, and there are software tools that can help provide more granular data for utilities to forecast that and to make set aside sort of customized amounts of reserved hosting capacity so that there will be some available on those circuits for those rooftop generators. I think where this discussion is revealed is there's really a threshold issue, which is this arbitrary system-wide cap means that a project that is applying to a feeder that only has 5 megawatts of capacity, is entitled to move forward and be studied and interconnect. A project that is interconnecting to a circuit that has, in the case of a 34.5 kV line, 10 megawatts, does not, right? And in BGE or in Potomac Edison, the utility is going to study those projects. They're going to go through the steps in the level 4 interconnection process and look to see, can we safely interconnect this? If we can't, on the current circuit, what upgrades may need to be required in order to safely interconnect that? And so what I think that what CCSA and the solar developers are looking for here is a path to moving away from this arbitrary limit and moving back to what's in the level 4 interconnection process, which is there's going to be a feasibility study, there's going to be a system impact study, and then there's going to be a facility study, and we're going to look at your specific project and see what it takes to safely interconnect it. And if it turns out that an express feeder is the only way to safely interconnect this project, then that's what will be necessary from an engineering standpoint. But if there is room on this, based on the specific characteristics of your feeder, your substation, your feeder, your circuit, to interconnect up to 15 megawatts or up to 20 megawatts or up to 25 megawatts, we're not going to cut everybody off at 10 megawatts anymore. Thank you.
So, Mr. Seegers, anything you want to?
Actually, I wanted to give the work group leader a chance to weigh in. I think he was doing.
Well, actually, I was
he
going to turn to him after you. So, if you want to say something before that, or I'll just turn.
I would have to defer to my subject matter experts on that, Your Honor. See if they.
Was there
anything to add?
Again, I mean, go ahead and add it as long as we don't get too far in the weeds. So, from an engineering perspective, for the non-engineers up here.
Yeah, Abdul Rahman again. In terms of removing those total arbitrary limit, like we say, that's the direction that we're going. But if we don't have these software capabilities, it's definitely a possibility of us compromising safety and the reliability of the whole system. And that's where we have this limit right now until we feel safe that we have these. And we, as much as we gear towards accommodating more DER in the system, but we also have a responsibility and a concern for safety of the public as well. So that's something that we have in mind, and we want to be sure that we have the systems in place and we actually working in that direction. We having our sign models being tested, I think, right before the end of this month, and just to see where we're at. And once we feel comfortable with those and all other integrations that we have in place, right now, we can't just assume based on minimum daytime load or peak load of the feeder to just make assumptions in accommodating more DER. This might change. And we also have reliability asset, safety asset in the feeder as well, like ACR or switches in the feeder. So if we just rely on just the load profile and make those assumptions, there's still need for coordination studies, and this might create nuisance tripping in the circuit and taking off customers that are actually online that's supposed to have power, and we just take them offline because there's some DER that we connected somewhere that we didn't pay attention and how a downstream circuit will react to this. So us moving in the same direction is allowing us to do that granular studies in allowing us to be more certain whilst we're moving those limits. And I don't want to jump in front of it, but we actually, before 2020, we actually moving and we actually working on the TIR, and that's why I think this is a working group discussion, and actually trying to make some changes on those limits. But I can't speak to that right now because we're working on that internally. And once we are comfortable with all the software enhancement that we're putting in place, we definitely we move into that granular circuit by circuit analysis. And mind you, Your Honor, we have like 15,000 feeders across, so we might need that batch analysis instead of individuals. Because if we say right now we will go to this direction, that means we have to do 15,000 studies of feeders and publish those 15,000 different hosting capacities for each feeder, because that's a circuit by circuit basis, and that's the capability that we don't have right now. Okay. That's the whole issue. Yeah. We don't have that capability to do 15,000 studies right now for 15,000 feeders and publish 15,000 hosting capacity for each individual feeder.
Okay. All right. Thanks. So, Mr. Burkowski, and I guess what I'd like to know, you had talked earlier about other things this work group was going to be dealing with that, are priorities, but so I guess I want to get a sense as to, if this thing gets kicked to your work group. I mean, are we talking some examination somewhere pretty far down the road, or is this something that can be done sooner?
Well, as far as looking at it further, we really cannot take it on until after we file our next petition for rulemaking, which I'm targeting for October 1st of this year, because we have some very aggressive Drive Act deadlines, and I need to get regulations in front of the commission by October 1st, and I just don't want to divert the work group to discuss this. But I'll say that the work group has discussed this, and I am, with all due respect to all the different positions, this is a very simple issue that I think we're making way too complicated. This is a classic case of, in my opinion, over-engineering by PHI. I want to say that I respect PHI's technical capabilities. In fact, a lot of the regulations, when we first started back in 2017, PHI was way ahead, and they still are way ahead of the Maryland utilities as far as their capabilities. Their hosting capacity maps are, excellent. They've got good capabilities, and we codified a lot of what they were doing, including subject to check. I think they had the concept of reserve hosting capacity, and we codified it, but we put some guardrails around it. We did not want it to be administratively set. We felt that it was a good idea to basically reserve some capacity for solar. And this whole business about SIME and things of that nature, that is not really the issue here. The real issue, and I would agree with CCSA's comments, Samantha's comments, the real issue is just having a method to just set aside some hosting capacity for solar. And it doesn't take circuit software or things of that nature. All it takes is a matrix, in my opinion, that, you have a couple factors that you consider. You consider the voltage of the circuit, you consider the, density, customer density of the circuit, whether it's urban, suburban, rural, and you just have different numbers based on those factors, and you apply them. Why does it have to get more complicated than that? I really don't know, in the absence of having, DER forecasting software. I don't feel that we should be making the perfect solution out there the enemy of the good. We need to get these regulations approved. I'm not for changing the may to shall, because I do think it's going to just gum things up, it's because it's going to, again, defer being able to get the existing regulations, which are a whole plethora of good regulations out there waiting to be implemented, that would be held up from this. I really just feel that the solution is just for PEPCO to go back, and maybe as a part of a motion, the commission can just say PEPCO should go back and just tell us, how they're going to be able to, segregate circuits a little bit better, because the intent of the regulations back in 2019 was for the utilities to start to move in that area, and we recognize in the wording of the regulations that there are factors that they could consider in lieu of having the ultimate DER forecasting solution. And I would say, regarding putting this back to the work group, I've been communicating with PEPCO, their SMEs, for 6 months prior to our petition for rulemaking. I've had emails asking them questions about why couldn't they do something, and I think that's probably what BGE and PE are doing. They're probably not taking, and over-engineering this, if you will. And I do think that we're over-engineering this. And I'm really hopeful that maybe PHI can come up with something that just looks at reserving capacity and not waiting for the perfect solution with SIME software and things of that nature.
All right, so Mr. Bugelmans, let me put it to you this way. If we grant your request and change may to shall, it's my view that we actually do need to republish the regulations, because I view that as a significant enough change to make us go through the process again. So is this issue important enough to your members that it needs to be done, even at the risk of having to go back to, I guess, start when it comes to the regulation process?
It's absolutely worth republishing. I mean, we've seen today and in PHI's comments what their interpretation of the regulation is, and I understand the argument about intent. I mean, we made that argument in our comments, but without really clarifying that in the regulations, I think it severely limits the Commission's authority. So I recognize this is the final rulemaking session and everyone wants to wrap this up, but this is important enough and it is a big enough issue that we would support republication.
There, go ahead.
Okay, I have a question for Mr. Prokowski. So you heard what Ms. Weaver talked about in terms of being able to do analysis even without the software, so sort of looking at customer density. And so, does that make sense to you that to the extent that the utility doesn't have the necessary software, there's still other tools in the toolbox where they can do some analysis? Do you agree with her?
Yes, and that's exactly the point I have made in emails to PEPCO SMEs in the past, that why can't they do something along the line of a matrix approach that's more simplistic. I really just feel like even if you had DER forecasting software, there's always probabilities involved, and I do think that we're just trying to make this more complicated than it needs to be.
Right. So, Mr. Chair, I had sort of suggested that perhaps we have sort of an off-ramp for the utilities, but as Mr. Seeger said, that he could always come to us if he needs a waiver. I don't think we need to put waiver language here, and I'm sort of inclined to just change the may to shall.
All right, well, all right, so I move that we amend COMAR 20.50.09.06 Q1C to read: a utility shall determine the amount of reserve hosting capacity on a restricted circuit based on a circuit-specific assessment of distribution energy resource forecast or other factors, including customer density, type of area served, and customer demographics of the circuit. Commissioner Sussman?
Aye.
Commissioner Barbe?
Aye.
Commissioner Richard?
Aye.
I vote aye. And given that, I move that we republish the following draft revised regulations in accordance with today's proceedings in the Maryland Register for notice and comment.
Can I just ask one question on that? Are there any of the regulations we could go ahead and adopt, finally published today, or are they all linked?
It's an all, it's all
all
or nothing.
I just wanted to.
Yeah, no, I understand. So, but yeah,
wanted to
apparently
ask.
it comes as a package. So, so just so we're straight. So I move that we republish the following draft revised regulations in accordance with today's proceedings in the Maryland Register for notice and comment, subject to non-substantive changes necessary to conform to COMAR drafting requirements, and that would be COMAR 20.50.09.02, COMAR 20.50.09.06, COMAR 20.50.09.07, COMAR 20.50.09.09, COMAR 2050.09.10, COMAR 20.50.09.12, COMAR 20.50.09.13 and Comar 20.50.09.14. Commissioner Sussman.
Aye.
Commissioner Barve. Aye. Commissioner Richard.
Aye.
I vote aye. And I think that adjourns our rulemaking today.